fortunate to have join us on the phone lines and one of the spokespersons of the second respondent in this particular petition by the name Nana Ajua Asante. And Nana Ajua is that young lady who is pretty much out there in the media lately. A lot is being written about her. I want to talk to her about the court processes as have ensued so far, where we are now and where things are likely to go. So thank you very much, Nana Ajua, for joining us here on the ABS.
Good morning, Benjamin, and greeting your listeners.
Yes, Nana Ajua, 30th December, a petition was filed in respect of election 2020 and the result as had been declared by the chairperson of the Electoral Commission. Clearly, the petitioner seems not pleased with something. What has been the processes as so far have ensued, and where are we at right now?
Yes, so as you rightly said, the petition was filed on the 30th of December as per CI 99, which are the rules that guide the election petition. We entered appearance and filed our answer on the 9th of January. That is within the 10-day limit. The EC also filed their appearance and entered appearance and filed their answer, and the process was to be kick-started. However, the petitioner, in a bid to delay the process, filed an application to amend the petition because the petition was fraught with mistakes. It's quite curious that a petitioner who is complaining about mistakes, and his petition is, should I say, majorly grounded on mistakes that were made by the Electoral Commissioner, are in their application, in their petition, had a petition that was fraught with mistakes. So they filed an application to amend. The court granted leave to amend, and then they came back, also in a bid to delay, to file a request to admit facts and a request to inspect documents. These requests are not applications before the court, but there were certain timelines, and they were requesting for certain documents to be made available to them by the EC. In another bid to delay, they filed an application for leave to serve interrogatories, and these were 12 questions that they wanted the court to give them leave to ask the Electoral Commission. The court heard the application and subsequently dismissed the application on grounds that the questions that they wanted to ask were not relevant to the matter in dispute. Then we went on we thought that, okay, now trial will finally commence, only for the petitioner to file an application for review of the decision of the court when it dismissed the application for leave to serve interrogatories. So we had to also sit through that, and the court dismissed the application once again. I would like to say categorically that we are happy that, of course, all these applications that we vehemently opposed were dismissed. But more importantly, the dismissal was grounded in law and tried principles of law that are known to all of us as practicing lawyers. So after the application for review was dismissed, hallelujah, now trial can commence. So the witnesses of the petitioner mounted the witness box. In actual fact, with the petition, the petitioner indicated that he will call 5 witnesses. However, he filed 2 witness statements, and as such, the assumption was that he will call 2 witnesses. So his first witness was Johnson Asiedu Kpessa. Johnson Asiedu Kpessa mounted the witness box, was taken to rigorous cross-examination, which exposed the lack of weight of the petition that is before the court. The evidence he gave and the cross-examination indicated that his evidence was of little or no probative value. Then the second witness also mounted the witness box, and I dare say even worse or even less probative value was added to the case of the petitioner with the evidence of the second witness. I suspect that based on the poor performance of their witnesses, they then decided that, you know what, we need to call a third witness to fill in the gaps that are in our witness statement. So as at now, even though they filed 2 witness statements, the day before yesterday in court, we all saw we were all surprised when there were some proceedings that took place in camera. But I suspect that based on what happened in camera, then the petitioner was given the permission to call a third witness. We heard on the floor in court, in open court, that it was due to health reasons that a third witness had to be called, and the witness couldn't file their witness statement. So yesterday we all found out that this witness is Mr. Rojo Metonunu. That is the second person who was in the strong room and acting as the agent of the petitioner and the NDC. So today we are going back to court, and we are going to hear the testimony of Rojo Metonunu. So that's where we are in this process. It's unfortunate there have been so many delays at the instance of the petitioner, which is quite curious, because when you bring a matter to court, in normal practice, you are the one who is actually in a hurry for the matter to be dispensed with. But because this petition does not meet the threshold of Article 64 of the 1992 Constitution, and it is devoid of substance, and we actually, in our answer, raised a preliminary legal objection and urged the court to dismiss the matter without going into the merits, because it is devoid of substance and does not disclose any reasonable cause of action. But the court, that is in its wisdom, and the law is in the bosom of the judges, decided that the preliminary legal objection will be heard at the end of the case, and it was actually set down as issue number 1. So the evidence that has been adduced, to be honest, vindicates us and shows that in actual fact this matter should be dismissed because it lacks substance. That is what it is.
Nana Joa, let's talk about your preliminary legal objection. It was expected by many that, typical of a preliminary objection, the rest of the processes will be stayed for that to be heard. And so when the court did indicate that it was going to rule on it as part of the judgment that is going to be given at the end of the entire process, people's expectation was that you were going to seek for a review of that particular decision by the court. Why didn't your team do that?
So we, as we have indicated from the beginning, are poised to defend this matter. And what is important is that His Excellency Nana Addo obtained more than 50% of the total valid votes cast. So we are ready either way to defend the matter, and we do not want to further delay the matter. The court is the one that is the final arbiter, and if the court in its wisdom feels that the preliminary legal objection is better heard, is better determined at the end of the matter, we are okay with that. It was unfortunate. We were not too happy when the court decided that the preliminary legal objection will not be heard at the beginning of the matter before trial. But we are okay. We do not want to further delay the matter. And as we said, we know that this is an empty petition and it will fall on all fours no matter how long it takes. So as part of our strategy, we decided to respect the direction of the court.
It's when you look at the witness statements of the 2 witnesses that have come so far for the petitioner, it is that of the second witness that talks a lot about the happenings within the National Collation Center. But very curiously, he is the one that your lead counsel spent the least time with. It was curious to many, and a lot were asking, why was this the case?
When there is a matter before the court and the issues are put down for trial, it should give you an indication of what is material and what is important to the determination of the case. What occurred in the strong view and the complaint of the petitioner should be the evidence adduced by the second witness should have been evidence that was going to show to the court, to demonstrate to the court that one, the petitioner and another Danko or no one reached the threshold of 50% plus of total valid cash, or that this allegation of her breach of Article 296 of the Constitution and her not being transparent biased was not fully, she actually was biased, or she was not transparent. However, the evidence, even the witness of the second witness of the petitioner, did not allude to any of these. And natural fact, as I said, his testimony was of little probative value. There was no need for us to belabor the point. And the very, very important question that was asked by our lead counsel was whether the electoral commissioner has the authority to instruct him. And as long as he answered no, that's what's important for us. So it's not about the length of your witness statement. It's not about the length of cross-examination or the length which a counsel is on his feet that determines the strength of the plaintiff's case. It's not about the flowery language you use, but it's about the materiality of the evidence of use. And that is what is important.